We're on the record.
We're on the record in case number 4:17 CR3038, United States of America versus Michael Wayne Parsons. Counsel, please enter your appearance.
Good afternoon, Your Honor. Jan Sharp, Assistant United States Attorney, appearing on behalf of the United States.
And John Vanderslice on behalf of Mr. Parsons.
Are you Michael Wayne Parsons?
Are we on the record?
Yes, we are.
Good morning, Your Honor, or good afternoon. Let the record show that I was just brought in here by force against my will, and the officer directly behind me assaulted me, threw me to the ground, drugged me in here. I've got broken ribs, broken arm, multiple injuries from previous assaults, and I just sustained another one by this gentleman behind me. I want that to be on the record, first of all. Also, the fictitious person and the birth certificate have been surrendered to the court.
Please stay seated. You must stay seated.
Birth certificate there. Let the record show that by special appearance, Ambassador Parsons of the Chilcotin Nation, country of the Chilcotin, the beneficiary, I'm here and I reserve all of my rights without prejudice, UCC 1-308, the Vienna Convention on Diplomatic Relations, and the Montevideo Convention, having already surrendered the fictitious person and birth certificate into the well of this court. This court lacks jurisdiction, and I have no business with this court. Am I free to go?
No.
I will instruct you as the trustee to dispose of the charge, pay off any debts, and compensate me for the damages.
Are you Michael Wayne Parsons?
I am not the fictitious person that you seek. You're seeking, according to this affidavit, a corporate entity, Michael Wayne Parsons. I am not that person. I'm not the fiduciary, surety, or trustee for that corporate entity or trust.
All right.
I'm a live man. This court is not an Article III court. As an ambassador of another country, according to the Constitution, Article III, Section 2, all matters pertaining to ambassadors, the original jurisdiction and sole jurisdiction is with the Article III, Section 2 Supreme Court. This is not that. This court lacks jurisdiction.
All right. Are you saying you are not Michael Wayne Parsons?
I am not the person in the indictment. That is a fictitious person.
What is your name?
Saying.
What is your name?
I am Ambassador Parsons of the Chilcotin Nation, country of the Chilcotin. I am not the person, the fictitious person that is in this indictment. That is not me.
All right. Now, Ambassador Parsons, what is your first name?
I'm referred to as Ambassador Parsons for the record.
All right.
I do not consent to this forum. I do not understand this forum. This gentleman just approached me moments earlier, and I tried to ask questions. He could not answer any of the questions.
All right. What I'm going to do is, first of all, we'll have to have an identity hearing. And interestingly, my understanding is that you have refused to be processed by the marshals, which would include your DNA and your fingerprints. You are hereby ordered to submit to processing by the marshals. They will go ahead and do that, even if it's necessary to do it involuntarily.
I would like to be heard on that matter. I don't consent to that under the United States Supreme Court ruling under Title 42, 2000 BB, the Religious Freedoms Restoration Act. It is against my religious objections. I do not do TB shots, or I do not do any unknown foreign substances into my body, and they're trying to force a TB test upon me is in violation of United States Code and Supreme Court rulings that say that if I'm not symptomatic, they can't force me against my will. I've never done a TB test. I don't consent to those now. It is against my rights as a human being given to me by my Creator not to give up my DNA, which is in violation of the Fifth Amendment also, and it's in violation of the Universal Supreme Court Act of the Chilcotin Nation. I am not subject to the jurisdiction of this court. This court does not have jurisdiction over me.
The court does have jurisdiction over you. You are hereby ordered, and the marshals are hereby ordered, to process you, which would include the DNA and would include the fingerprinting and any other matters, and photographing, I assume.
I do not consent to this offer.
It doesn't make any difference.
I do not consent to this offer. I do not accept your offer.
It's not an offer. It's an order.
An order is an offer. I do not consent to these proceedings. I am the beneficiary, the living soul. I am not the corporate fiction. And this is after a corporate fiction. I'm a live man.
At this time, though, I am going to have Mr. Sharp advise you of what the charges are against Michael Wayne Parsons and the possible penalty on those charges. Mr. Sharp?
Mr. Parsons, the grand jury seated in the District of Nebraska has returned a one-count indictment that charges you in that count with being a convicted felon in possession of a firearm, specifically described AR-15 rifle and over 600 rounds of ammunition. If you are convicted of that offense, it's punishable by up to 10 years in prison, up to a $250,000 fine, or both. There could also be up to a 3-year term of supervised release that could be imposed after any period of incarceration. Lastly, in the event of your conviction, there would also be a $100 special assessment that would be applied. Do you understand what you're charged with and what the possible penalties are?
I don't understand any of this because I'm not the Michael Wayne Parsons that you're seeking. That is a corporate fiction. And you said that you're referencing an AR-15. That's not what's listed in this sheet of paper in front of me for that corporate fiction. So you're reading into the record things that do not exist on this indictment. I object to the reading of this indictment that is fraud because Mr. Sharp did not read it as it is written.
All right. I'm going to advise you of your constitutional rights. You have the right to remain silent. What that means is you do not have to say anything about the charges in any court proceeding. You do not have to provide a statement to the government or anybody asking for information on behalf of the government. If you've already provided a statement, you do not have to say anything more. And if you ever start answering questions, you can stop answering those questions at any time. But you need to understand that what you choose to say to anyone other than your lawyer can and will be used against you. Do you understand your right to remain silent?
I don't understand any of this, nor do I waive any of my rights. My rights are not constitutional. They come from my Creator, God. They're recognized by the Constitution. The Constitution doesn't give me anything. This government doesn't give me anything.
Do you understand that you can remain silent if you want to?
I don't understand what you're doing because you don't have jurisdiction.
All right. You have the right to counsel, and if you cannot afford counsel, counsel will be appointed for you at no cost to you. Do you want an attorney?
I don't waive any of my rights.
Do you want an attorney? It's a yes or no question.
I don't waive any of my rights.
All right.
I don't understand what you're doing. That's the point of this whole matter is you're trying to bait and switch me from counsel to an attorney. They're two different things. Legal counsel and an attorney are two different things.
The only people that can represent you in this court as counsel are attorneys.
What form of court is this?
This is the United States District Court for the District of Nebraska.
And what form of court?
The United States District Court for the District of Nebraska.
That's not the form of court. Is this an admiralty court?
No.
Is this a constitutional court?
Yes.
So you're following the Constitution?
When I advise you that you have the right to an attorney, yes.
Do you recognize Article 3, Section 2 as an ambassador? You
I'm
don't
no
have
longer
jurisdiction
answering your
over
questions,
me.
sir.
You're not following the Constitution if you're not recognizing Article 3.
I'm no longer answering your questions, sir, and I'm no longer listening to bogus arguments.
Then this court is rogue and it's a fraud. Everything that you do
can
from
take
here
up
on,
in motion.
You're violating international law. You're committing war crimes right now by holding me. Now that you know that I'm an ambassador, you're holding me against my will. You're committing international war crimes. I have here a document proving my position as an ambassador of the Chilcotin Nation signed by the hereditary Grand Chief Stanley Stump Sr. himself from January 1st, 2016, before the alleged charge against this fictitious entity, Ambassador Associate Justice Michael Parsons of the Chilcotin Nation, member of the Chilcotin National Congress of the country of Chilcotin, formerly British Columbia, Canada. Michael Parsons is not a U.S. citizen. Michael Parsons has diplomatic immunity based on the appointment to the position of ambassador by hereditary Grand Chief of the Chilcotin Nation, country of the Chilcotin, Stanley Stump Sr., on January 1st, 2016, and based on the Vienna Convention on Diplomatic Relations, Article 39, which states that upon appointment by the country to the position of ambassador, they are recognized and have diplomatic immunity. Ambassador Michael Parsons has been exonerated of all prior convictions and charges from the United States by the Universal Supreme Court of the Chilcotin, which under the rules of reciprocity and the Constitution of the Chilcotin Nation and National Congress must be upheld by the United States. And under Title 28, Section 1330, the United States is bound to uphold that order. Therefore, based on all the above, I, Hereditary Grand Chief Stanley Stump Sr., request immediate release of Ambassador Michael Parsons from detention in accordance with the Vienna Convention on Diplomatic Relations. I have a copy of my tribal card, my status card. It's blown up so that you may see it. And it clearly lists me as the ambassador of the Chilcotin Nation. I will enter that for the record, along with a copy of the letter from the Grand Chief Stanley Stump Sr. himself.
All right. You have the right to a jury trial. At that trial, you'll have the right to see and hear any witnesses who testify against you and to have them cross-examine on your behalf. You'll have the right to call witnesses for you, and if they will not come voluntarily, you can get a court order called a subpoena to make them come and testify. At the trial, you can testify yourself if you want to, or you can exercise your right to remain silent. If you remain silent at the trial, the jury will not be allowed to consider will not be allowed to consider your silence in deciding whether you are guilty. And at the trial, the government will not get a conviction against you unless it is able to prove to every single juror that you are guilty beyond a reasonable doubt. This case is set for I'm going to enter a not guilty plea on your behalf. This case is set for trial, for a 5-day trial before Judge Gerard for February 20th. I'll order reciprocal discovery under Rule 16 to be exchanged within 14 days of today. Pre-trial motions need to be filed by January 17th. Any reason not to otherwise adopt the normal progression schedule, Mr. Sharp?
No, Your Honor.
Judge, I'm going to be out of the office during the week of February 20th, and I presume that we're going to have a jury trial. Would it be possible to move this up a week or two?
Sure. Actually, he is not requesting counsel, so I'm not sure that...
I have not waived counsel. I demand to maintain all of my rights. I've not waived anything.
Then you are appointed as counsel, and you'd like it earlier than that.
I would, Judge.
The problem we have is this gentleman has already told me he doesn't want this case. He said he's got plenty of cases, doesn't want this case because of the publicity, apparently.
I don't think it's because of that. How about February 12th?
That would be great, Judge. Thank you.
I have no confidence in this individual. He has not given counsel.
Actually, could we go to February 5th?
Sure.
Because I suspect that even though it's scheduled for a 5-day trial, it may take longer.
Yes. February 5th. That sounds like a wonderful time.
Thank you.
One problem we also have is that the state has not shown any proof of a bond in this matter. Does the state have a bond in this matter?
No. That brings us to the issue of detention. What is the government's position?
No, not that
Your
bond.
Honor,
I mean the
I'm
bond
asking
for
the
the
court to
charge.
take judicial notice of the pretrial services report. We are requesting detention both on flight risk and on danger to the community. In addition to what's in the pretrial services report, I would proffer to the court that prior to the events that led to the instant indictment, Mr. Parsons was awaiting trial in Tennessee on release with a bracelet which he cut off.
Facts not in evidence. Objection. Those facts are not in evidence.
Country of Canada when he stopped here in the state of Nebraska.
None of those
all of
facts,
those reasons we are asking for detention.
None of those facts are in evidence. There's nothing in evidence to support that. That is not true.
This is what we're going to do.
There was nothing cut off.
If you'll allow me to speak, I am in charge.
Ma'am, I have a wife and a farm.
It doesn't make any difference how many wives you have or how many farms you have.
Just one for 33 years.
The issue for me is whether you pose a risk of flight and a risk of danger to the community if you are released. We're looking at having a detention hearing. I'm looking at having that. And then also we have to deal with this TB test issue. There is Turner versus Safely gives you the 4 factors that I have to look at in determining whether I can order the TB test. I also need to find out from the marshals what their policy is, what the purpose of the policy is, what alternatives we have, those types of things. And so I'm kind of looking at doing the detention hearing on the afternoon of the 20th. Does that work?
Of December?
Yes.
Yes.
Okay.
And Your Honor, if I could, I don't know if you can see this. I'm going to
Judge, the 20th, Wednesday at what time are you?
I'm looking at 2:30. Does that work for everyone?
Yes.
Yes.
Okay. We'll do a detention hearing at 2:30, and I'd like to cover the TB issue at the same time. Between now and then, the marshals are entitled, if they choose to place him in segregation under the 8th Circuit law, that you cannot, under 8th Circuit law, you cannot expose other people to potential risk of tuberculosis inside of a penal institution. And if that is a concern for the marshal or for the Saline County Jail where he is being held, you may place him in segregation until we make a decision as to the merits under the Turner versus Safely criteria.
And currently I'm in segregation, and that's being addressed, Your Honor. And I do have with me a copy of my ordination. I'm an ordained minister, Native American minister, and the fact is that I've never done a TB test. It is against my religion. I don't do any drugs, shots, nothing that I know is harmful. And the manufacturer of that shot does not, they state, they do not guarantee the safety or effectiveness of it because they can't guarantee what they put in there. That's the manufacturer. And
so your concern is about the shot itself and the pinprick test itself, is that correct?
I don't put anything into my body that is potentially harmful or is not helpful. I've never done a TB test for that very reason. And the fact is that I've been locked up in the county jail in Phelps for 30 days, in LCC up the road here for going on a month and a half. And they had me in isolation for 10 days. They recognized, okay, he's not symptomatic. I went into general population. In Tipton County, they know that I don't do these shots straight into general population. In the West Tennessee detention facility, I was in segregation, not so much because of the TB shot, but because of this false accusation of a flight risk. If Your Honor looks at the record, you'll see that on the false charge in Tipton County, the hearing that I did not attend was because I never had a directive to appear. Prior to that, for going on 2 years, every month I would show up in that courtroom like clockwork. I was out on a $500 bond. I live in the community with my wife. I've got a farm. We're easily accessible. The only thing is that they never gave me an order or directive or anything. I had no indication I was supposed to appear on that day. Otherwise, I would have been there. I was working in my ministry with the Chilcotin Nation, working to help them get a timber deal so they can get their kids back from the foster system.
All right. And Mr. Sharp, I'm also, by then we should have the DNA fingerprints, those types of things. So let's do the identity hearing fully as well on Wednesday afternoon at 2 o'clock.
Judge, I have one last issue. If I could pass this up to you. It's a letter that I tried to get faxed to you last week. I do have a suit, regular clothes as opposed to this. If I could request the graciousness of Your Honor to allow me to be in proper dress.
Everybody who is detained that comes before this court, this is their proper dress, and so you will be wearing that. Anything else that we need to take up at this time?
No, Your Honor.
No, Judge.
We are in recess.
Would you like me to put your papers back in the envelope for you?